Good morning.
Good morning. May it please the court. Allison Renfro on behalf of the appellant mother, Savannah Johnson. I would please like to reserve 3 minutes for rebuttal.
3 minutes, certainly.
The issues on this appeal involved whether the trial court abused its discretion when it ordered an excessive and or unreasonable amount of step-parent visitation, and whether the trial court erred when it failed to issue findings of fact and conclusions of law when it modified a custody order and ordered that there was no child support. I'll begin with the step-parent visitation issue. We concede that step-parent visitation is in this child's best interest. The issue is the step-parent visitation ordered was excessive and unreasonable. Last year in September 2024, this court just addressed whether the issue of a non-parent visitation was excessive and or unreasonable. In the case of Evans v. Derrick, a Court of Appeal decision that was cited in our brief that Judge Stafford joined. This case guides us what's excessive and unreasonable in a non-parent situation. There, the trial court gave the non-parents, the grandparents, every other Thursday through Monday, 2 weeks in the summer, and some holiday visits. This court concluded that that visitation schedule was excessive and unreasonable and vacated the visitation schedule and remanded it for further proceedings to establish a schedule consistent with the...
And in this case, instead of 2 weeks, we have 1 week in the summer, and we don't have the holidays, if I remember correctly.
That is correct. There's 1 week in the summer, and it's Thursday at 7 through Sunday at 7 every other weekend is the visitation schedule ordered.
As far as the weekend visitation, if I recall correctly from the trial court order, didn't the trial court say your client worked every weekend or wanted to work every weekend? Is that accurate?
Yes, the trial court found that my client does work every weekend. However, the trial court ordered that my client could have weekends in the summer. The trial court ordered that the mother and the father would have week on, week off in the summer. So apparently her work schedule was an impediment to receiving parenting time in the summer, just 9 to 10 months out of the year during the school year, which in our opinion makes no sense.
What was that inconsistent with what your client had said?
It is not inconsistent. My client testified that she did work weekends.
Okay, so consequently then that would be the time that the court would be looking at visitation. Is that accurate?
Yes, however, we would submit to the court that the trial court said that it would not interfere with her parenting time because she works weekends, but many parents work weekdays, myself included, as an example, but that does not preclude me from having any weekday time. And we would submit that just because she works weekends, it shouldn't preclude her from having any weekend time during the school year with her child.
Was that your proposal during the hearing, or was there a proposal?
There was a proposal. The proposal was it was a joint custody schedule with the biological father where the parents would alternate 2 days on, 2 days off, and then alternate the weekends. So what the trial court essentially did was skip any opportunity my client had to have that weekend time and replace that time with the non-parents visitation schedule.
I'm just trying to get the framework in my mind of what the trial court was working with, because obviously we're looking at an abuse of discretion, correct? So if the trial court, I want to make sure that my facts are not inaccurate.
Yes.
So there was no question that your client testified she wants to work on the weekends.
Correct.
So that obviously would be the time that the trial court would look to for visitation purposes.
And that's apparently what the trial court did.
Okay. And why was that wrong?
That was wrong because it interfered with the parent-child relationship. And what I mean by that is the Tennessee Supreme Court's decision in Lovelace v. Copley, in the grandparents' rights context, also quoted in the Evans decision, said that reasonable visitation would be carefully crafted to afford both, one, the visitation necessary to avoid substantial harm to the child, and two, to minimize the extent possible interference with the parent-child relationship. We would submit that this trial court's order was an abuse of discretion and interfered with the parent-child relationship because it reduced the mother's time from 11 out of 14 days with the child to 4 out of 14 days with the child. It's illogical to find that reducing that time by 100 days would not interfere with the parent-child relationship. It's our position that's illogical to conclude that saying the mother could have no weekends during the school year would not interfere with the parent-child relationship. The trial court heard testimony that the minor child has 2 siblings at her mother's house, but per the trial court's order, the child would only be with mother during a few waking hours during the school year, 9 out of 10 months. And it's illogical to conclude that that would not interfere with the mother's parent-child relationship.
And you talk about the parent-child relationship, but this stepfather, for the first 6 or 7 years, everybody thought he was the father, not the stepfather. And this gentleman lived with the mother and the child thought he was the father, and he thought he was the father. The trial court has found that I shouldn't say minimizing, but the trial court found that the stepfather should have visitation because it would be harmful to the child not to. So aren't we balancing parental interest with that of the child? And we can't just look at the mother's parenting time interest.
Correct. We're balancing a few interests here. We're seeing what would be the schedule necessary to avoid substantial harm to the child. The trial court did not say that the stepfather needed the exact same day-to-day schedule he enjoyed when the parties got divorced and enjoyed for 2 years to avoid substantial harm to the child. The trial court just basically took the plan proposed by the parties and slapped the step-parent's time on top of it, the exact same time that he had been enjoying. And in the Evans v. Derrick case, the grandparents tried to argue, well, the visitation we want is reasonable because that's what was previously agreed to. Yes, the parties previously agreed that the step-parent could have Thursday through Sunday, but that was before the biological father was in the picture.
So I want to make sure, because you've said this twice now.
Yes.
Are you equating step-parent visitation and grandparent visitation the same way?
I believe that they are comparable in the sense that they are both non-parents, and this court has found that non-parents don't have the same constitutional rights as parents. So I put them in a category by
I think
themselves.
the Supreme Court has found that, but
Oh,
yes.
yes, thank you. So non-parents go in their own category, parents have the constitutional rights. And as this court knows, parents have fundamental liberty interests to the care, custody, and control of their child. It's one of the oldest recognized judicial fundamental liberty interests. And under both Tennessee and federal constitutions, parents have the freedom to make decisions for their children.
But now this is a little bit different. Just as the grandparent statute does, the step-parent visitation statute also says if you make these specific findings, these extraordinary findings, that there's substantial harm or it's in the best interest of the child, that those fundamental rights of a parent can be infringed upon. Is that accurate?
That is accurate. The statute.
But let me follow up here before you start off on me. In this situation, the trial court made some rather strong findings. The trial court essentially said that the step-parent was basically the best parent that the child had. Would that be accurate? I know you don't necessarily agree with that, but would you agree that that's what the trial court found?
That's what the trial court found.
Okay. So how then did the trial court abuse its discretion when the legislature said that the step-parent can infringe upon these parental rights with these findings that have been made?
The legislator said you can infringe upon the constitutional rights, but the visitation needs to be reasonable. And even the statute contemplates that upon a determination, visitation would be in the best interest. Reasonable visitation may be ordered. And that's where I think this court's decision in Evans v. Derrick guides us when it's unreasonable.
Well, reasonable here is rather than dividing the time of the child between two people, we have three people.
Yes, and the plan is a disaster. The child is in 3 different homes in a given week, and the trial court didn't issue findings of fact and conclusions of law as to why that was in the child's best interest. The trial court didn't issue findings of fact and conclusions of law as to why the mother, who had been the primary residential parent, gets reduced from 11 out of 14 days to 4 out of 14 days, and that the biological dad, who had known the child for 5 months, gets 7 out of 14 days. We don't know why the trial court reached that conclusion, because there's no findings of fact, and there should have been pursuant to the rule of procedure.
What type findings are you suggesting the trial court needed to make?
The best interest analysis under 366106.
I think the trial court was pretty clear about what was in the best interest of the child, but what specifically are you saying is lacking here?
The best interest factors of 36106 to perform the analysis of who was the primary residential parent, who performed the majority of the parenting responsibilities, who's likely to facilitate and encourage a relationship, those sort of factors.
Was this plan that the trial court implemented, was it different than what had already been implemented between the biological parents?
The biological parents.
As far as decision-making and those issues?
Yes, in terms of decision-making, not in terms of time. The biological parents proposed that they would have a joint residential schedule. The trial court did not order a joint residential schedule.
Thank you.
Yes. So in the brief time I've got left, I would state that the mother would request her attorney's fees under the prevailing party analysis of 365103, because this is a custody schedule, and we just respectfully request that the trial court's order be remanded for findings of fact and conclusions of law as to what the schedule and to why no child support was ordered, and vacate and remand the award of step-parent visitation for further proceedings as to what step-parent visitation is, quote, reasonable. Thank you.
Thank you very much. Good morning, and will you be sharing time?
Good morning, Your Honors. Yes, sir, I will. Mr. Stewart and I have agreed to evenly divide the 15 minutes.
Very good. All right, thank you.
Yes, sir. May it please the court, my name is Joseph Johnson. I represent the appellee Christopher Hobbs. He is the biological father in this matter. Your Honor, at the close, I'm going to ask you to affirm the ruling of the trial court. We believe, as I will explain in my argument, that the trial court ruled correctly. If it pleases the court, I would like to go through the appellant's arguments in the order that was listed in her brief. The first issue, Your Honor, I don't believe that this is a case that requires that the trial court find that a material change in circumstance exists in order to modify a permanent parenting plan. My client, the biological father, filed a petition to establish his parental rights. In that petition, that he was creating, or attempting to create a permanent parenting plan, and that permanent parenting plan was eventually created. The appellant takes issues that there were not findings of fact as to that parenting plan. Your Honors, I would submit that the biological father, my client, and the mother came up with a parenting plan. Both signed that parenting plan and submitted that parenting plan to the court. The court adopted that parenting plan with some modifications as to the step-parent rights, but in that permanent parenting plan, the mother and father both agreed that parenting plan was in the best interest of this child.
So are you saying the trial court did not find a material change of circumstances?
Your Honor, I don't believe respectfully that it was necessary in the juvenile court to find a material change of circumstance.
I understand, but isn't the mere fact that you're now dividing visitation between 3 people as opposed to 2 people a material change of circumstances?
Yes, Your Honor, it could be, and my client's position, we are not opposed, and we think the court correctly ruled as to the step-parent visitation.
I think the other side says, or the mother says that there's no problem with step-parent visitation. But isn't the mere fact we now have step-parent visitation a material change of circumstances?
Your Honor, I would say that, yes, that is a change of circumstance, but with my
Pretty
clients.
material when you're dividing it between one more person, isn't it?
Sure, yes, Your Honor. I would also say that the appellant alleges that it's an illogical decision to give my client the equivalent time as the mother. The parties submitted this plan. The parties agreed to this plan. The mother agreed for my client to have 182 days of parenting time with this child. And the distinction that I would raise from some of the cases that are cited in the appellant's brief is that in this case, the mother and the father were not opposed to each other at trial. There was not, they submitted an agreed order or agreed proposed parenting plan. So I would submit that the court was not required to find.
Did their agreed order include parenting time for the stepfather?
No, sir. No, Your Honor. That was the part that the court did change. And I would submit that the court did make the appropriate findings of fact and conclusions of law as the court meticulously went through the step-parent visitation and determined that there was a substantial relationship and harm would exist to this child if the step-parent visitation was not granted, and then looked to the mother's work schedule and found the time to implement the step-parent visitation with the least negative effect to either parent.
So your client is in favor of affirming the trial court's decision that includes step-parent time?
Yes, Your Honor, that's correct. And that's probably a unique position to be in front of Your Honor arguing. But the stepfather was in this child's life from day one. He raised this child as his own. Right. And now that my client found out years later and took the appropriate steps to be in this child's life, but we are in agreement with the step-parent visitation.
Okay.
And
Let me, I don't want to take you out of your argument, but I want to make sure that we let you address it in the time that you have. The mother says you should be paying, your client should be paying child support. What's your position?
Your Honor, I respectfully, at the time this order was entered, the stepfather was paying child support to the mother. The party submitted an order that specifically said there would be no child support ordered. I think at the time it would have been unjust to have stepfather paying child support to the mother through the Chancery Court of Franklin County and the father paying child support to the mother through the Juvenile Court of Franklin County.
Why is that unequitable or inequitable?
Due to the amount of,
or unfair, I'm sorry.
Oh, respectfully, Your Honor, due to the amount of parenting time the mother is receiving.
So what did the trial court say about that agreement, other than there was an agreement?
Your Honor, I believe the trial court stated that the parents submitted an agreed permanent parenting plan and that the court was adopting that plan with the amendment with the change that the trial court was implementing step-parent visitation.
So essentially your client's getting the visitation that the parties, the parents agreed to.
Yes, Your Honor.
The actual parents agreed to, but he's not paying child support.
That's correct, Your Honor. No child support was awarded. And I would submit, Your Honor, that if child support was awarded, the mother may be paying child support to my client due to the number of days of parenting time.
Thank you.
Yes, Your Honor. And finally, just to wrap up, we would submit that the mother is not entitled to her attorney fees in this matter. All throughout the trial court's record, the trial court found that this case arose through the actions of the mother, that the mother did not inform the father that he was the father of this child. The trial court found the mother's testimony sometimes to not always be credible. So we do not believe this would be a reasonable time to approve mother's attorney's fees. And in conclusion, we would ask that you affirm the judgment of the trial court. Thank you.
Thank you. Good morning, Mr. Stewart.
Good morning. Good morning. I'll have to reflect on the fact that some 40-plus years ago I stood before this bench when I was sworn in before the Supreme Court, and each and every time I come before this court or the Supreme Court, it's an honor and privilege to be here.
Well, we're glad to have you and your colleagues here today.
Thank you. I'm Mark Stewart for the appellee, Chad Grider. I represent the step-parent, the stepfather in this case. I've listened to arguments of the appellant, and she removed some of my arguments when I believe she stipulated that my client is entitled to visitation, so the question before the court would be the extent to which my client would have visitation as a step-parent under the provisions of TCA Section 36-6-303. As I reflected on my preparations for argument today, it occurred to me that I think the trial court and this court face an unusual circumstance in that the court has to consider the provisions of that statute with regard to my client's request for step-parent visitation and the provisions of 36-6-106 that deal generally with child custody cases and the best interest standard that's articulated in that statute. Your Honor, respectfully, I would note that...
That poses an interesting question, Mr. Stewart.
Yes, sir.
Is the trial court required to go through both statutes in its analysis? And if so, what application does the trial court do there?
Yes, sir. First of all, with regard to my client, the provisions of 36-6-303 are the most pertinent and applicable. Because of my client's unique position as a step-parent, whether or not, first of all, we met the standard of proving substantial harm to the child is likely in the event that all contact and visitation is terminated.
So we think apparently been stipulated to today. So
that's correct. So that argument's behind us.
So we've got the step-parent visitation statute.
Yes, sir.
Does the trial court then have to overlay the general visitation statute?
Well, Your Honor, I would suggest to the court that because the biological parents submitted an agreed parenting plan at the trial of this case, they stipulated with regard to what that schedule would be, and therefore the trial court would not have to necessarily participate in the detailed analysis that might otherwise be required because they agreed to a schedule.
But they had agreed between themselves, not as to your client, which certainly detracts from the amount of time available.
Well, that's true, Your Honor, and that's the difficult thing about this case that this court has obviously addressed in other contexts, particularly grandparent visitation cases. We have the difficult question of how this child, who's loved by 3 individuals, will be shared between them so that they can all enjoy their rights under the statute. And, Your Honor, I suggest to the court that 36-6-303 having been met, then it just becomes a question of what that schedule would be.
Well, it creates a pool of 3 people, doesn't it?
It does, and it's difficult to do. It's difficult enough in divorce cases with 2. This is even more challenging. But I think the facts are relevant to and the court's aware of this. Parties, my client was married to the mother, the appellant, in August of 2018 after being led to believe that he was the father of her unborn child. He didn't learn until some 2+ years later that he was not, in fact, the father of this child. He was listed on the birth certificate as this child's father. In the divorce proceedings after the parties decided to end their marriage, he insisted and she agreed in a permanent parenting plan to give him visitation, and he assumed the obligation, though not required to do so under the law, to pay child support and to share in those extracurricular expenses. He's complied with every requirement of him that a natural biological father would have complied with. And so until June of 2023, the biological father was not contacted. Now, I want to say too, and echo what my counsel said for the biological father, these two men stand together in this proceeding and both ask the court to affirm what the trial court has ruled in this case. Initially, things were not so, but they are now.
Is that inclusive of child support?
Well, the child support issue is a different question, Your Honor, and I would suggest to the court a reading of the child support statute would be pertinent, at least as it applies to my client. The 366101A1 provides, inter alia, that the court may decree that suitable support be made by the natural parents or those who stand in the place of natural parents by adoption. Your Honor, I would submit to the court that my client does not meet either one of those categories. And since our legislature has spoken on that issue, I don't know that I think this court is bound by the statute, and I don't know that a finding of child support by my client as a step parent, when there's no provision in TCA 366303 makes reference to that, then I think this court could be beyond the scope of what our legislature has directed with regard to child support. I know that's a bold position, but Your Honor, I think a plain reading of the statute supports that argument.
Do we have a conflict on child support between the Chancery Court ruling and the juvenile court ruling?
Well, I think there is an inherent conflict, Your Honor. However, I think this order in this juvenile court proceeding supersedes that case in the sense that child support was based upon a different parenting schedule that no longer exists. And therefore, this court dealing with the natural parents and a step-parent petition at the same time had to adjudicate the rights of the parties and balance out those rights for what is in the best interest of the child. And I submit to the court that while there may not be an express detailed finding, that the court did so by applying the analysis under 366303 and trying to determine what was in the best interest of this child. It's respectfully our position there was no abuse of discretion by the trial court. The trial court had the discretion to make this determination in order to avoid substantial harm emotionally to this child. The record is replete with statements by this child about my client being the father, her father, and the love that was shown to her, the care, the support, and the stability. And I would submit that the case of Ray v. Ray, which I came across in preparation, which is a May 18, 2004 decision of this court, where they said therein that the step-parent's visitation, they said, quote, "The evidence in the record indicates that Mr. Ray, who was in his role as stepfather, raised the twins as his own for several years. Mr. Ray has remained a steady, positive, loving parental figure in the lives of these two children." I would suggest to the court that that same analysis could be applied here to my client and his rights as a step-parent.
Thank you, Mr. Stewart.
Thank you, Your Honors.
We'll hear rebuttal. What is your position on child support?
Our position that it was appropriate, it would be appropriate for child support to be ordered, and that there was no findings given as to why it wouldn't be appropriate. The child support guidelines is sort of the default the court needs to work with. No proof as to incomes, work-related credits were given, so it would make sense to remand this case to get those facts.
So what was the trial court's reasoning? Was it anything other than this was the agreement between the parties?
That's correct. The trial court didn't make many findings at all about the agreement between the parties, except this is what they agreed upon, so I'm going to adopt it. So it would be helpful to know what the trial court would say about child support.
Well, let me take you to a different spot. The analysis that we discussed about we've got step-parent visitation, which there's no question you agree step-parent visitation is appropriate.
Yes.
Okay, so we take that off the table. Once that analysis is made, is it your position that the trial court then has to analyze all three of the parties under the general visitation statute? What is it, 106, I think?
366106. I don't think the step-parent is analyzed under it, but the statute explicitly says, in any other proceeding requiring the court to make a custody determination, this is a custody determination. The factors needed to have been considered, and they just weren't. The court references them very briefly, and says very little proof was presented as to these factors, but doesn't perform the required analysis.
Is there proof in the record for this court to do that?
I don't think there's adequate proof, so I think it needs to be remanded for further proceedings. I would like to mention regarding Mother's work schedule, Mother doesn't work Thursday. The step-parent was awarded Thursday through Sunday. The trial court didn't submit findings of facts as to why that was the schedule to avoid substantial harm to the child that would not interfere with the parent-child relationship. Mother's not working Thursday. Why can't she have the parenting time? Why can't her weekends be skipped one weekend and then the biological father's weekend be skipped the next month? Why does it always have to be her weekend just because she works? It seems like the court honed in on that one factor when there's many factors to be considered. And briefly, because counsel brought up Ray, I would also like to reference Ray. And Ray makes comments that these custody awards are not to punish parents for past behavior. The decision's for the best interest of the child. Thank you.
Thanks to all three of you for your, thanks to all three of you for your arguments. We'll take this matter under advisement. We're going to take a very short break, and we will be back.